Our last lectures, we've been talking about the history of tribal courts and the history of tribal governments. Now we need to move up to kind of a more modern approach, what's actually going on now in tribal courts as they're in operation today. I want to tell this story because it was interesting to me at the time that I did it. I had been asked to teach tribal sovereignty at the Native American Studies Department here at OU, and we did that for a little while. And then I decided, I need to be more involved with tribes because I really wasn't as involved in tribes at that time. So I made application to become a tribal judge for the Sac and Fox Nation, and that was some years ago. And I didn't know a lot about tribal governments. As we've talked about today, they're kind of complex and they're diverse, and there's all kinds of activities that go on by tribal governments, and how they perform and do their activities is a mystery to most people who are not involved in the tribe. So the Business Council reviewed my resume, and then they called me up and they said, oh gosh, we'd like for you to come and be a judge for the Sac and Fox Nation. Now the Sac and Fox Nation is not a big tribe. They have, I don't know, I'm going to say 4,500 people. I don't know if that's accurate or not, but that's around. They're not a large tribe. And consequently, when you're not a large tribe, you don't have a lot of qualified tribal people that have law degrees or other professional degrees. And then out of that pool, you have to have somebody who wants to be a judge. Well, so they didn't have someone that fit the bill within their tribe, and so I asked to be tribal judge if they saw fit as a Chickasaw citizen. And they said, well, sure, that sounds good. I need you to come and meet with the General Counsel. The Business Council is going to make the recommendation, and as far as we're concerned, we approve you coming on as a tribal judge. So I show up for my interview with the tribal council, the General Tribal Council. And it's in an auditorium. It's a giant auditorium, and it has a stage on the front. And the General Counsel is not some embodiment of elected officials. It is basically the entire tribe that gets to come and make inquiry of you to see whether or not they want you to be their tribal judge. So me, along with others, were brought to the front of the stage and handed a microphone one at a time, and the people just lined up to ask us questions, and it could be any question of any variety, any kind, having to do with anything. That was kind of an unusual experience for me because I looked for something that had more maybe order and structure to it, and they asked some pretty pointed questions, oftentimes about cases that they had pending before the tribal court, so that was kind of a difficult issue. But then after they did the interview of you with all these folks up on stage, they also did their ballots while you're standing there watching, and they tallied them on a big screen behind you while you're waiting the outcome. And gosh, and those that didn't get chosen, didn't have the proper number of votes to get chosen, were escorted out of the building. And then those who were chosen, they had a brief greeting, and then they asked you to leave because then they had tribal business to conduct, and I'm not a member of the tribe. But the reason I tell that story is because you really can't know what kind of tribal government that you're dealing with unless you investigate it. And that's something that I learned at that time, and I'm trying to pass on to all those who want to enter tribal court. We're going to talk about jurisdiction. Jurisdiction is kind of a fundamental question that has to be asked of every case that comes before a tribal court. Jurisdiction is defined by the Supreme Court as exclusive, so you either have it or you don't. If you don't have it, someone else has it. So it's exclusive in that nature. If you start trying to examine jurisdiction generally, you have civil and criminal. The criminal jurisdiction has been limited, as we've talked about previously when we talked about the history. The Major Crimes Act takes away major crimes, criminal crimes from Indian tribes. The tribes have the authority over Indian on Indian crime within their communities. They lost it briefly with the Oliphant. There's a string of cases, Wheeler, Oliphant, Duro, in which Indian tribes had they didn't have, Oliphant stands for they don't have jurisdiction over non-Indians. The Duro case was you don't have jurisdiction over non-member Indians. So you may be an Indian of another tribe, but you're not an Indian of this tribe, so no jurisdiction. Congress thought that was probably going too far, so they came in with a fix after the Duro decision and said, no, you now have, through statutory authority, jurisdiction over other member Indians that are not members of your tribe. If they're within your boundaries and they're doing activity, then you now have jurisdiction over them. Those kinds of things are the essence questions that are asked every time a case comes to tribal court, whether it be civil or criminal. It started with the General Crimes Act of 1817. It comes forward with the Major Crimes Act of 1885. We have Public Law 280, which is a grant of jurisdiction to states. Some states opted in, some states opted out. Oklahoma is a state that did not want to accept that jurisdictional responsibility, so consequently tribes have jurisdiction within Indian country, which is defined by statute. That covers all reservations, Indian communities, and other allotted lands. And the boundary that a tribe has goes pre-allotment. There's also trust land that is Indian country, and it may have some different definitions. Trust land is land that tribal governments ask the federal government to put into trust for them. They purchase a land and then they make application to put it into trust. They have, in a non-Public Law 280 state, they're going to have jurisdiction over that area, much like a casino. That might be a description of trust property where Indian country is defined and Indian tribes have jurisdiction. Now there's been most criminal jurisdiction has been taken away from tribes as it relates to non-Indians. The general feeling is, and understand the Supreme Court looks at all tribal courts the same, just like one entity, even though they're not. They're very diverse and different. But that's the legal view of it. And as a result, the Supreme Court is, this is kind of something that is carried forward from treaty relationships between the United States and United States and Indian tribes. The jurisdictional question is, I don't want my people punished by laws that they're unfamiliar with and customs that they're going to find, odd or they're unaware of. So if my people come into your area and commit a crime, I want to prosecute them myself, and I'll determine what kind of outcome that should maintain. Well, the Supreme Court has kind of carried that kind of treaty understanding forward and says the same thing. Non-Indians will not be treated in a fair way because tribal courts not only have tribal law, but they have customs and traditions that imprint the decisions that are made in tribal courts. And consequently, non-tribal members could never understand the detailed custom and traditions that they're being held to a high standard in relationship to. So, non-Indians tribes never have jurisdiction over non-Indians. Now, as we roll forward in time, that begins to change because that leaves a gap in Indian country. Non-Indian players can come into Indian country, commit a crime, and if the state has no jurisdiction, like in Oklahoma, then the federal government is the only one left to prosecute that activity. The federal government normally holds their prosecutions for more important matters. High money, high crime, whatever it is. Misdemeanors, on the other hand, which are committed in Indian country by non-Indians, no jurisdiction exists for the state nor the tribe, and as a result, the federal government then would have to have a misdemeanor jurisdictional docket. Some federal prosecutors have done so. I think there's one over on the eastern side of the state. I think the Western District may have a misdemeanor docket as well to try to take care of some of that gap that exists in Indian country and has for some years. But as we roll forward through a variety of lobbying and understanding about this gap that exists in Indian country about criminal matters, Congress has since passed some acts which grant jurisdiction over non-members. First, they took it all away, generally. I mean, not all of it, but a lot of it away, and now they're starting to grant some back. The Tribal Law and Order Act of 2010 expands tribal court jurisdiction and adds to the severity of punishment a tribe can administer. Tribal courts, as a misdemeanor, can increase their ability to fine for acts of $5,000 up to $5,000 and put people in jail for up to 3 years for an offense. Prior to the Tribal Law and Order Act, tribes were only capable of prosecuting misdemeanors. At first it was 6 months and a $500 fine. Later on it shifted to 1 year and a $5,000 fine. And now we see the Tribal Law and Order Act that allows $5,000 and up to 3 years in jail for an offense. That gives additional rights to defendants, such as free representation in criminal cases. But a tribe must opt into the act in order to accept the expansion of power. As of today, I don't know how many tribes that have opted into the Tribal Law and Order Act. I know there's probably a handful, if not more. Part of the trouble with the Tribal Law and Order Act and other grants of criminal jurisdiction is tribes generally don't have jails. Now, there are a few that do. I think the Mississippi Choctaw have some sort of way to incarcerate people. The Sac and Fox Nation has a juvenile detention center. So there are some, and they're slowly finding that is a service that they need to provide in Indian country. But generally speaking, most tribes don't have jails. In 2012, the federal government decided to do a Violence Against Women Act, called VAWA. If you'll go to your acronym sheets, you'll find these things listed there. It's a special domestic violence criminal jurisdiction grant from the federal government. This jurisdiction authorizes tribes to criminally prosecute non-Indians for crimes of domestic violence, dating violence, or violation of protective orders. But however, in order for tribes to utilize this criminal jurisdiction, tribe must provide certain enumerated due process protections, including protections required in the Tribal Law and Order Act, which can increase the incarceration of a non-Indian for up to 3 years for an offense, and can be stacked for only 3 years, 3 offenses at a time, for a total of 9 years of incarceration, which is a pretty big grant of criminal jurisdiction by the federal government. But that is a kind of an overview of how criminal justice works, and so consequently, tribes don't have a huge criminal docket generally. Now, with casinos, that gave tribes an opportunity to do a lot more criminal prosecutions than they might have done otherwise. Misdemeanor crimes of, small amounts of marijuana, other drug activity, assault, resisting arrest, public intox, all those kind of minor things fall into this array, and tribes oftentimes do have criminal dockets as they relate to that. But some tribes thought, well, gosh, we could be a little bit more creative, and we could deal with these crimes in another manner, and perhaps we could deal with them civilly as opposed to criminally. And the thing that you have to understand about what we're talking about here is tribes have the ability to hold somebody in contempt of court for violating of a court order. If it's civil contempt, you can incarcerate someone for a period of time, but the view is that that person really has the keys in his or her pocket. If you'll do what the court tells you to do, you could get out at any time. Where if you have a criminal contempt of court, then you're putting someone in jail for violating a court order directly, or some other kind of misbehavior or conduct that's of a criminal nature. Well, if you have a civil action involving a non-tribal member, and they commit some sort of criminal contempt, can a tribal court incarcerate that person? Maybe not. Those are kind of legal questions that maybe have yet to be answered, but they're complicated, as you've seen. We've talked about a long framework that operates to direct us on how to behave in tribal courts. So that's a difficult issue, and that's something that tribal judges oftentimes are creative in trying to figure out how we're going to resolve some of these pressures they feel in tribal court. You have to remember in tribal court for a criminal prosecution that it's exclusive. Keep that in mind, meaning that they either have it or they don't. What kinds of things control those activities of jurisdiction? Well, you have to examine several things when you go through this process. Was it an Indian perpetrator or an Indian victim? Does it fall under the Major Crimes Act? And does the tribe maintain jurisdiction for this activity? If you have an Indian perpetrator and a non-Indian victim, who would have jurisdiction to prosecute that crime? Well, the federal government would have the ability to prosecute. The state may have the ability to prosecute. If it's a non-Indian perpetrator and an Indian victim, you might find yourself in state court. If you have a non-Indian perpetrator and a non-Indian victim in Indian country, that's probably state jurisdiction in Oklahoma. So where it occurs, who the perpetrator is and who the victim is critical. Or in reverse, if you have a non-Indian perpetrator, Indian victim, where did it occur? All of those things play an important part in determining jurisdictional limits in Indian country. I think I'll talk just briefly about civil jurisdiction. I'm going to start with that because it overlaps some of this criminal jurisdiction activity. There was a Creek judge named Judge Moore. He was a fine judge and a good legal scholar. But he was administering a case of where at a casino we had an individual who was dealing drugs in the casino. He was driving a Hummer, had a meth pipe in the ashtray, going in and out of the casino to do his business. But Judge Moore knew that and had recognized a long time ago, we don't have any way to curtail that kind of activity. That's a federal issue if the gentleman's a non-Indian. So they passed some statutes that allowed them to take civil penalties against someone who does that kind of activity and addresses through their property. So consequently, instead of charging them with a crime, it was in violation of a civil authority, and they confiscated his Hummer. Well, you know, Hummer's a very expensive vehicle, and they certainly thought that that would not stand scrutiny, because really it was just a way to circumvent the fact that they didn't have criminal jurisdiction over this individual, and they still wanted to punish him. But in fact, it held up. Judge Moore was able to take that Hummer from that gentleman, and then he was prosecuted as well through the federal government for whatever crimes he may have committed while he visited Indian country. So I bring that up as a segue, really, that tribal courts and tribal judges oftentimes, and tribal governments, oftentimes use their legislative ability to put pressure on people through a civil action that might normally be a criminal action. And that's kind of an important use of tribal sovereignty and tribal authority. But when you're addressing these issues, the question starts at a very, very early point of, does the police, the tribal police, have the power to arrest and hold for another jurisdiction? Even though you don't have the power to prosecute a non-Indian for their criminal activity, you probably do have the power to hold that person for state or federal authorities who do have the power to criminally prosecute them. So you can be arrested and held while they search out a jurisdictional relief by one of the other sovereigns that have jurisdiction over you. One of the other authorities is probably to arrest you and take you to the border of Indian country, wherever that may be, and turn you loose and ask you not to return. There's also the exercise power of exclusion or banishment. There may be an opportunity as well, now this is kind of a legal question, but an opportunity to exercise jurisdiction through consent or stipulation of a non-Indian. Maybe a non-Indian committed a crime in Indian country, and he really doesn't want to be prosecuted by the federal government. So he says, I'd just soon be prosecuted by the tribal government, even if you incarcerate me or do whatever. I think that there are probably tribal courts out there that are exercising this authority, but ultimately they know that they can't really hold this person. I've heard tell of a Hickory Apache judge who prosecuted a non-Indian for some sort of domestic violence, and this was not having to do with the Violence Against Women Act, but basically gave him some time in jail, and the guy said, you know what, I'd rather do that than be prosecuted by the federal government for this crime. So the cell door was left open. He could leave whenever he wanted to, but he was ordered to jail for a period of time. He was happy to go ahead and serve that time and pay the fines and do whatever to avoid federal prosecution. And that was kind of the end of it. And you know what? That was probably harmonious for that tribal community because he lived on the reservation with an Indian lady, tribal lady. Tribes are oftentimes, like I talked about Judge Moore, decriminalizing certain acts that may be criminal in nature in some fashion to make sure that they can ascertain some sort of pressure on individuals outside of imprisonment and fines through a criminal code. That's being creative on how to get around the lack of criminal jurisdiction that is found in Indian country. Forfeiture laws and contempt power, those are powers a tribal court can use that don't necessarily have to do with criminal activity. But anyway, I just wanted to kind of bring those things to light to you, to let you know that there are courts out there that are doing creative things to try to accommodate the fact that they don't have criminal jurisdiction over non-Indians within Indian country, except in those few areas where the federal government has granted them so. Our next topic is going to be tribal civil jurisdiction when we return.